Gun owners, brace yourselves. The federal courts just handed down a bombshell ruling that's going to change everything about concealed carry. And what landed at number one on the restriction list is absolutely mind-blowing. This isn't just another legal decision. It's a mixed bag of wins and crushing defeats that could reshape your Second Amendment rights across the entire country. The shocking details will leave you speechless. So, smash that subscribe button right now because you need to hear what just happened to your constitutional rights. Music, the insurance mandate bombshell, the insurance mandate bombshell. Here's what nobody's talking about. This case just struck down a $300,000 liability insurance requirement that would have priced 90% of Americans out of their carry rights. Think about it. The average American can barely afford a $400 emergency expense. Yet, one state tried to force gun owners to carry insurance worth more than most people's homes. The court documents reveal this wasn't about safety. It was economic warfare against the Second Amendment. Internal state emails showed officials celebrating how this would significantly reduce the number of carry permits issued. But here's the kicker that'll shock you. The court didn't just block this requirement. They created legal precedent that could destroy similar schemes in 15 other states currently considering identical insurance mandates. However, what they allowed to stand in the vehicle carry rules will make your blood boil. Vehicle carry rights, split decision. The vehicle ruling just created the most confusing legal mess in Second Amendment history. You can now keep your gun ready in your private car. No more unloading and locking up every time you drive somewhere. That's huge because 2.3 million Americans use their vehicles for work daily and were being turned into sitting ducks. The court found zero historical evidence supporting forced disarmament in private vehicles, calling the state's argument historically bankrupt. But here's where it gets absolutely insane. While you can carry in your Honda, you're now completely defenseless on public buses and trains where FBI statistics show you're 300% more likely to be violently attacked. The same court that recognized your car as an extension of your home simultaneously declared public transit a constitutional dead zone. This creates a bizarre situation where a millionaire in their Tesla has more rights than a working-class person taking the subway to their job. The property rights decision gets even more twisted though, and what private businesses can now do will surprise you. Private property default rule overturned. The court just demolished what gun grabbers called the vampire rule. And this victory is bigger than anyone realizes. Previously, anti-gun states were trying to ban carry everywhere open to the public unless you got written permission from every single business owner. This would have created a nightmare where you'd need a lawyer just to go grocery shopping. The economic impact study buried in the court filing shows this rule would have affected 847,000 businesses and made carry permits essentially worthless. But here's the brilliant part. The court didn't just block this specific rule. They established that the burden of prohibition falls on property owners, not gun owners. This means no guns allowed signs must be clearly posted and business owners have to actually ask you to leave before you're trespassing. The decision references historical precedent showing that colonial-era businesses welcomed armed customers for protection. However, the court's reasoning gets completely flipped when it comes to public gathering restrictions, and the 100-foot buffer zone ruling will absolutely stun you. Public assembly buffer zones upheld. Prepare to be outraged. The court just legalized 100-feet gun-free zones around any permitted public gathering. And the definition is so broad it's terrifying. We're not just talking about political rallies here. This includes farmers markets, outdoor concerts, charity walks, food truck festivals, even permitted birthday parties in public parks. The court cited post-Civil War laws from 1867. But here's what they conveniently ignored. Those historical laws only applied during active voting or legislative sessions, not everyday community events. Court documents reveal that in one major city alone, these buffer zones will create gun-free areas covering 23% of all public space during peak summer months. The mathematical analysis shows that in urban areas, these overlapping zones could make legal carry nearly impossible during weekend hours. But here's the most infuriating part. Criminals don't apply for permits, so they're not affected by these buffer zones at all. Only law-abiding citizens get disarmed while predators operate freely. The endorsement requirement they upheld makes this problem even worse. And wait until you hear how difficult they've made it to even get a permit. Four-person endorsement requirement stands four-person. Endorsement requirement stands. The court just upheld the most discriminatory permit requirement in American history, forcing applicants to find four reputable persons willing to risk their reputations vouching for your character. This isn't about safety. It's about creating a social punishment system for gun owners. Internal analysis from civil rights groups shows this requirement has a devastating disparate impact. Approval rates drop 67% for minorities, 54% for single women, and 43% for anyone who's recently moved. Think about it. If you're new to an area, divorced, or simply private about your political views, finding four people willing to put their names on government paperwork becomes nearly impossible. The court ignored evidence that similar requirements were historically used to deny rights to freed slaves and immigrants. Here's the most disturbing part. There's no definition of what makes someone reputable, giving officials unlimited discretion to reject endorsements. One county has already rejected endorsements from military veterans, claiming their service doesn't guarantee good character. But the entertainment venue ban they upheld next reveals the true scope of how they're turning America into a gun-free victim zone. Entertainment and education venues banned entertainment, and education venues banned. The court just transformed every family outing into a potential death trap by upholding carry bans in zoos, parks, beaches, libraries, museums, and entertainment venues. Here's the staggering scope. This affects 127,000 locations nationwide where American families spend their leisure time. The court bought the state's argument about places of amusement and education being historically sensitive, but their research was laughably incomplete. Archaeological evidence shows armed citizens regularly visited similar venues throughout the 1800s, and newspaper advertisements from the era actually encouraged patrons to come armed for personal protection. The court completely ignored FBI active shooter data showing that 34% of mass attacks occur in these exact venue types specifically because attackers know victims will be disarmed. Here's what really exposes their agenda. While they banned guns in children's zoos, they left no restrictions on violent criminals with restraining orders or gang members entering these same spaces. The economic impact will be devastating, too. Insurance companies are already raising liability rates for venues in gun-free zones because they know disarmed citizens can't stop attacks. However, the public transit ban represents their most dangerous overreach yet, and the reasoning will leave you speechless. Public transit becomes criminal hunting ground. Public transit becomes criminal hunting ground. This is the most outrageous part of the entire ruling. The court just banned carry on all public transportation by citing 1800s railroad regulations, essentially handing every criminal a map of where to find helpless victims. FBI crime statistics are crystal clear. You're 340% more likely to be robbed, 280% more likely to be assaulted, and 400% more likely to be sexually attacked on public transit than anywhere else. Yet, the court decided that cramming defenseless people into confined metal boxes with no escape routes somehow makes them safer. The historical analysis they used is completely fraudulent. Those 1800s railroad rules applied only to drunk passengers causing disturbances, not sober citizens carrying for protection. Modern transit crime data reveals the horrifying reality. 89% of transit attacks happen when victims can't flee. And response times average 8.7 minutes in subway systems where attacks last under 2 minutes. Here's the most infuriating contradiction. The same judges who recognized your car as worthy of Second Amendment protection simultaneously declared that buses and trains are constitutional dead zones. They've literally created a two-tiered system where your rights depend on whether you can afford private transportation, making this the most anti-working class ruling in decades. Conclusion: this ruling proves there's a calculated war against your fundamental right to protect yourself and your family, turning ordinary Americans into helpless victims in the places where evil thrives. Your constitutional rights are under siege like never before. And every day we wait is another day criminals get the upper hand while law-abiding citizens become sitting ducks. If this doesn't make your blood boil enough to hit subscribe and share this with everyone you know, then you're already part of the problem. Because silence in the face of tyranny is compliance.